Good afternoon and welcome everyone. Thank you for joining us on this Friday afternoon. And I'm sure this is not what Fridays are meant for, of what we're going to talk about in the context of the recent ruling, which has obviously created a flutter amongst the industry and all the participants. But we feel it is still a very, very important development. And while a lot has been talked about over the last couple of weeks in respect of this ruling, we believe there would be a worthwhile investment from all of you to kind of listen to some of our experts. We've tried to structure it in a manner where we can bring in our experts both from an indirect tax as well as from a direct tax perspective. And more importantly, also kind of try to focus more on what this ruling kind of translates in terms of impact for the industry on one hand. Second, also maybe leave some thoughts for all of us and of course for the policymakers as to what needs to be done, and if at all they believe that there is a need, and we will of course talk about it as we go along. So it's really something that we do hope will be a worthwhile investment of a Friday afternoon with us. We'll also try to cover questions because I'm sure there are a lot of questions in everyone's mind as we speak, and to that extent I would definitely love to kind of respond to many of those that we can, as many of those as we can. But we will, of course, so you please feel free to post questions in the chat box over there. So I think going forward, let me just set the backdrop. And I think as we all know, the industry, AIF industry has been growing significantly over the last few years. And I think I would attribute that to two important factors. One, tax certainty, which I think had eluded the industry for almost a decade. And I'm referring to the tax pass-through status. And we all know that kind of really stunted the growth in many ways. And that obviously came through around 2015-16, followed by very constructive changes to the exchange control provisions, FEMA provisions, which obviously opened up the industry for global participation. And these two developments, in my view, kind of form the bedrock of the government really promoting India as a manage in India jurisdiction as against invest in India alone. And I think that's really been something that the industry has bought into, and I think the global investors have seen comfort in. And we have seen the number of AIFs and several other onshore structures really kind of growing up. So obviously all of it going well, and I think industry was obviously starting to see a quantum jump, as I would look at it, and then gearing up for that. And suddenly I think obviously we saw end of June, CSAT, actually the body dealing with excise and service tax and GST, came out with this ruling in the context of ICICI Ventures for some of their funds. And obviously the ruling is in the context of service tax, but obviously we'll also understand from our experts here how it kind of impacts even the current regime in that sense. So I think we definitely had to start with, I'd like to quickly introduce the panelists here. I think first and foremost, I have Dinesh Agarwal, who's a partner with our indirect tax team and a very senior member within the practice as well, who would be kind of one going through the essentials of the ruling, and we'll try to keep that as brief as possible. And then, of course, we would have a set of questions and other discussion points, which will hopefully throw some more light on many of the pertinent issues. Also joining me on the panel here is Bijal Ajinkya. I think obviously a lot of you from the industry would know her. She's a tax and a funds partner. And obviously been into the space and have examined some of these structures, set up some of these structures over the last many years. So that's where it would be useful to also hear what this ruling means from a direct tax perspective. And of course, at my end, I would also try to bring in the industry perspective and also maybe some messaging for the policymakers as well. So I think with that background, I think what we would do to start with, and just to kind of give those who are new to the issue a bit of a backdrop on what this ruling is all about and what it really means in terms of the principles. I'll request Dinesh to kind of run us through a short presentation, and thereafter we'll obviously deep dive into the discussions from there on. So with that, can we please have the presentation? I do hope everyone's able to see that. Dinesh, over to you. Thank you.
Thank you, Siddharth, and thank you everyone for joining us in this lovely afternoon. So today is Friday, and let's ponder over this ICICI Econet Internet and Technology Fund versus Commissioner of Central Excise Bangalore judgment, which has created ripples inside the mutual fund industry as well as venture fund, and I don't know what else. Because if we try to understand the essence of this ruling or order, then I believe personally that this is going to have very wide ramifications beyond what is apparent. So let's begin. Mitesh, can we have next slide? So as everyone knows, India Econet and Internet Technology Fund is a registered venture capital fund under the regulations of the SEBI as a trust. As every trust, it's a pooling vehicle of the investment, which pulls investment from its contributors and member subscribers, and in turn they are getting allotted some units. And the fund which is received by the trust is managed by AMC, which is appointed by the trustees, and trustees in consultation with, AMC in consultation with trustees decide how to make investment decisions, how to invest it by using various other service providers. And trust has its own discretion to determine the waterfall distribution system of income and profits, and there is different classes of shares are there which gets predetermined income as and when whatever is agreed in the memorandum. There was an investigation which was started by the service tax authorities on the nature of the service which is provided by these funds, venture capital funds, to its subscribers, and that investigation led into issuance of so-called notice seeking recovery of service tax on LS service of managing pooled investment fund, and the period of dispute is 2005, 2006 to 2011-12. The period is also important because there have been changes in the law. So this particular ruling is with respect to the law as prevailed during 2005 to 2012. But then we believe that this ruling will also have and has impact not only on the period from 2012 to 2017 when there was a service tax regime, and now under GST regime from 2017 onward. So this ruling is not to be seen as if it's only a legacy issue, but it also has got present value in terms of how the authorities are going to look at these transactions. In this, after the investigation, so-called notices were issued to the ICICI Venture Fund, and then Commissioner passed an order upholding the demand of service tax. And being aggrieved, this was carried by the appellate before the sestet, and now we have a ruling from the sestet and that is what we are going to discuss. It's appropriate to say here that the issue has not reached finality, because since this is going to impact everyone, including ICICI, who is the appellant over here, and the demand involves huge amount. So this will be essentially carried before the Supreme Court, that is the appellate forum against these state orders. But till the time the Supreme Court adjusts the matter and decide either way, this order, until unless again stated by Supreme Court, will have its own currency. So this order actually is very relevant for our discussion. So let's, Mitesh, can we have change of the slide? Yeah. So before the state, ICICI, the appellant, was contending that service tax is not payable, as there is no distinction between trust and the contributor or beneficiary, because of the doctrine of mutuality, there is oneness. Trust and its beneficiary are one and single party, and therefore one cannot provide service to oneself, and therefore this should not be liable to tax. Then second argument put forth was that the kind of service, pooling of the investment and then getting it managed by the AMC, is beyond the service which is banking and other financial services, where the department wanted them to tax it. Because what they were saying is that we are only a pass-through or conduit. We don't provide any service to the beneficiary. Whatever service is being provided by the AMC, and therefore to that extent we should not be held liable for the service tax. Third one was that if at all there is a service which has been provided, then what is the nature of service and what is the consideration? So we are not charging anything from the subscriber for making investment, and therefore there is no consideration. Whatever fee is charged by the AMC, and therefore only that is the service provided by AMC. We have never charged anything, and to that extent again there is no service to the party or subscribers. And last, what department has done is that they have said that all the expenses which were incurred by the fund or trust during the course of managing these investments, all the expense side of the PL account were the consideration, and in that consideration they have also added carry interest or carried interest, which is allocated to class B and C kind of shares or units which carry higher allocation. So it was alleged that this is carried interest is nothing but performance fee, which has been characterized as a return on the investment, where the real nature of the this amount is the performance fee, and therefore to that extent it also be considered as an expense and not as a redistribution of the income. So those were the things. And then trustee also said that since trust is not a person itself, it's a juridical person, and during that time juridical person was not brought within the tax net, so you cannot really ask trust to pay tax. It should out to have been the trustees. So trustees should have been made parties, and to that extent again the demand notice should fail. So these were the contentions which were placed before the tribunal. And then it was what was the argument of the department? Let's see. So Mitesh, can we have next slide? Mitesh, can we have next slide? Yeah. So respondent being the department, they said that trust ought to be considered as a juridical person, and therefore all juridical person are within the tax net, because during the relevant period, commercial, what was the definition of taxable person was commercial concern or person, and person or commercial concern was not defined under the Act, and therefore by relying on the General Clauses Act and common parlance, even juridical person will or ought to be considered as a person liable under the tax net. Doctrine of mutuality, they considered it, and they say that it has been captured when third party benefit on account of appellant's activity. So it was not only the beneficiaries but AMC were also deriving benefit, and therefore the doctrine of mutuality is not acceptable. Then they said that the trust has already got registration under the various other regimes, like VCF registration has been procured from the SEBI, and therefore that points that VC should be considered as a commercial concern because the purpose of it is to earn profit for the beneficiaries. Government also pleaded that, like SEBI regulations, they are a special act, and therefore they should govern or prevail over the Indian Trust Act, which in a way sought to eliminate the distinction between beneficiary and the trust. Then on the part of expenses, they say that the disbursement to unit holders were net of the expenses, and therefore expenses incurred by the appellant to manage fund is nothing but a consideration received by the trust. And carried interest is not a return on investment, as it is hugely disproportionate to the investment. The reason they cited was that the ICICI venture was having a contribution of merely 0.0003% in the fund, whereas their return was in the range of say 20%. And therefore, if you look at or compare the investment vis-a-vis return, then it was hugely disproportionate. Hence, it ought to be characterized as a performance fee. So all these contentions were dealt by the members of the tribunal, and then they concluded. What is their conclusion? Let's see. So Mitesh, we can have next slide. Slide, please. Yeah. So doctrine of mutuality, they say that, and that is the first point which was argued. Doctrine of mutuality, trust has a distinct legal identity from its contributor and has a sole profit-making motive. Doctrine of mutuality does not exist between funds and its contributor. So, in fact, this was the thing which was said in the context of 2005 to 2012. But if we look at in the present scenario, in fact, in the present scenario of indirect taxation, doctrine of mutuality is also not applicable, because we have examples where housing societies, which are nothing but a kind of trust, are also subject to GST, and therefore doctrine of mutuality for the purpose of indirect taxation at least will not apply in the present case. Second, taxable person, because what they were saying, department, party was saying that we are not the person, we are trustee, and we don't have a distinct identity, and we are only an artificial juridical person, and therefore we should not be taxed, at least because from 2012 only the artificial juridical person was recognized as a person. So the council itself admitted that at least from 2012 onward, the trust has been, or artificial juridical person has been considered as a taxable person under the laws of indirect tax. Now coming to GST, we know it that even trust and artificial juridical persons has been declared or has been defined as a persons, and therefore this also remains invalid in the present scenario. Now taxable service, they are saying that what is the taxable service which we have provided to our contributor. So the tribunal said that funds are rendering services of portfolio management or assets management, which is classifiable under banking and financial services, to its contributor. And how they are providing it, because fund is collecting the money or investment from the contributors, subscribers, and that they are investing to make and generate profit. And then they are also controlling the disbursement, and therefore this is nothing but a portfolio management service rendered by trust to the contributors. Taxable value, what they say is that disbursement to various unit holders is net of the various charges like custodian fee, brokerage charges, JMC charges. Any amount retained out of the income distributable to subscriber is nothing but a consideration for the services so rendered. So even though there was no service consideration which was specified in the documents, they derived all the expenses side of the balance sheet or profit and loss account to be the consideration. And treatment of carried interest, they agreed with the contention of the department that it's not a return on investment. Instead, it's essentially in the nature of performance fee, hence can be part of the gross consideration of service. Here only I just want to interject and say that this is specifically whether it is in the nature of performance fee or not. In this particular case, there were some documents before the investigating agency or in the so-called notice, which suggested that at some point, even the ICICI was using the performance fee terminology against this disbursement. So there was some lacuna in their documentation or in their some problem in their documentation also, which led to these problems. So now this is where we stand, that in terms of doctrine of mutuality, taxable person, taxable service, taxable value, and treatment of carried interest, things have been decided by the tribunal, and all these has ramifications for the wider audience. Yes, Siddharth.
So sorry, yeah. So Dinesh, I think that's very, very helpful, and I think very well kind of laid out for the audience here in terms of what really the ruling is all about, and obviously the essential elements of it, which probably the industry will need to look, and obviously the Supreme Court will be looking into as. And we do hope that this goes into an appeal there, and then I think we do hope there is a quick resolution to the positions out there. I think before we come to the impact, I think a very, very pertinent question, because I think, as you rightly said, Dinesh, this is a ruling that stands today, and obviously it until the Supreme Court or the policymakers decide to kind of change the ratio in respect of this. We need to obviously examine this from the perspective of how this impacts and the applicability or the derivative of this. How would that really be seen from a direct tax perspective? And then that's where I think I would like to bring in Bijal to really say that while clearly the ruling today is in respect of the service tax, do you see this having whether as a principle any impact or from a direct tax perspective, and whether there could be any strong differentiator that can be argued? So maybe it would be helpful to get your perspective on that.
Sure. Thank you, sir. So I would say, a couple of points here. One is, of course, the key in any of these situations is really the documentation. To the extent that, the documentation is clear that it is, a return on investment. Unless there are strong factors to essentially showcase it as a performance fee or an additional, management fee, to that extent, the tax authorities in most probability would not really undertake a recharacterization. However, having said that, in situations where, the fund manager, or for that matter, the documents per se itself refer to it as a performance fee, to that extent, given the fact that we've always had, I would say, a system or a tax principle of, though tax planning is permissible and though within the four corners of law, however, if it is considered a sham from the start, or for that matter, if at all it's a transaction post, the general anti-avoidance provisions really coming into effect, then a recharacterization is possible. So in summary, yes, the principles can be applied. However, I would say that, it really depends on the manner in which the documentation is really worded. And of course, some of the other principles of doctrine of mutuality or, a trust being a separate entity are, I would say, not really sustainable at a higher level from a legal perspective.
Okay. So just so that we understand that while clearly from what we heard from Dinesh, that from an indirect tax perspective, both under the earlier regime, which is obviously the service tax under which, and more importantly, even under the current regime, the doctrine of mutuality and the recognition of a trust as an assessable person has been kind of well established into the law now. From a direct tax perspective, I think the principle still remains that trust would not be seen as a distinct entity. Is that a right conclusion from what you're saying?
Absolutely, Sid. So I would say I would divide this, response to this into buckets. One is a situation where we are looking at this from a trust law perspective. Under the trust law in itself, a trust is nothing but an obligation which is created on the trustee to be carried on for the purposes of the trust objective. Now, to that extent, when we do have a trust law in place, and this is like a regular common law trust, which was essentially, though it was meant for, personal asset protection and, at the point in time when it was introduced. However, over time, it has been used a number of times for business activities. In that situation, very important to note is that from a trust law perspective, the courts had never seen a trust as something which is distinct from the settlor, in this case, investor. And to that extent, even I would say in extreme situations of an insolvency, if assets were there in a trust, if at all the investors or settlor in this case were essentially, say, declared insolvent or had a creditor protection issue against them, assets in the trust actually would be called upon, which is where I would say that the doctrine of mutuality is extremely clear under the trust law principles. The second very important point to note here is that under the Income Tax Act, a trust is not considered a taxable entity. A trust per se is taxable only as a representative assessee. And I would just like to correct that statement. The trustee is only taxable in a representative capacity on behalf of and qua the beneficiaries, in this case, the investors itself. So to that extent, under income tax principle, it is extremely clear that a trust in itself is not a separate taxable entity, and it is only the trustee who's stepping into the shoes of each and every investor or beneficiary vis-a-vis any assessment on it. In fact, this particular argument has been laid very clearly in the case of the Karnataka High Court. Again, in the same case of ICICI Ventures, wherein the court itself has essentially held that in a case like a venture capital fund, the investors, when they contribute into the trust, are nothing but contributing into a revocable trust structure. And therefore, if tax has been paid, either at the fund level or for that matter at the investor level, it is the same tax which has to be paid, but only once. So I would say the principles under both trust law and tax law on the principle of mutuality are extremely clear.
So no, I think that's very interesting, and I think what's coming out is the trust law and the direct tax law clearly seems to be far more aligned in terms of the treatment of a trust vehicle, whereas obviously the indirect tax has obviously looked at these vehicles slightly differently. And in my own view, considering because I looking at the ruling, I also see that a lot of construct of why the trust should be treated as an entity has also been borrowed from the regulatory framework, and there has been several references to the SEBI, AIF, VCF regulations. I think the way I look at it, I think it's also maybe the tribunal needs to also understand that when SEBI looked at regulating the investing vehicles, I think there has been a slightly different perspective to it. I mean, independent of the nature of entity, I think it was felt more prudent for the regulator to regulate the vehicle, fund vehicle, rather than regulate the manager. And in fact, if you go back in history, for the AIF and the VCF regulation, there was a time where SEBI had also had considered that instead of regulating the fund vehicles, and which is would it be more prudent and more aligned to the global practices to register and regulate the investment manager, and which is how most developed markets do. So I think obviously from a regulatory investor protection and maybe from a systemic risk management perspective, if a regulator like SEBI has applied a registration and regulatory requirement to a trust or a fund versus a fund manager, I think that distinction and the role and responsibility that that regulator has kind of discharged through this structure should be kind of appreciated by the tribunal from that perspective, to avoid creating this multiplicity of interpretation. So anyway,
If I may just add here to what you said, is that today for a trust to be considered as a distinct entity from an indirect tax perspective, you really require a policy change here. Today, if at all, the legislation under which a trust is formed is extremely clear on the form of entity and the fact that it is not a distinct legal entity in itself. It is, I would say, pretty absurd to call it a separate entity in the form of a different legislation. Because when you are applying the rules of interpretation, you would have to go to the mother legislation of the trust law to understand the kind of vehicle. Now, very interestingly, in countries like the US and, Japan, where they wanted to have, a separate type of, trust legislation for such business-making profitable vehicles, they actually incorporated a law to essentially say, to that extent, though the entire, obligation and the duty vis-a-vis the manager and the investors is like a trust, but at the end of it, the business trust law, which they incorporated in these countries, essentially made the trust as a separate vehicle outside and different and distinct from its investor. And in the absence of us having a specific legislation in that particular manner, it would not be, I would say, legally tenable for a different, set of thinking to apply vis-a-vis each law in respect of trust.
So no, I think that's very comforting in a way to know that a direct tax, and we do hope that the direct tax authorities as well, I mean, do not get swayed by the ruling here, because there is a clear distinction in terms of the fundamental principles of how a trust is being looked at by under the direct tax law versus the indirect tax. So I think coming to you, Dinesh, I think in terms of treating the trust and the VCF as a service provider, and I think that seems to be a premise that has also been used in the ruling here. I mean, do you think that is how the indirect tax authorities look at the relationship between a fund, a pooling vehicle, and an investor? Because I think that is how the genesis of the issue is coming from there, that they are viewing this fund as a service provider for also some of the expenses. I think, can you shed some more light on that?
Siddharth, so far as trust and beneficiary relationship is concerned, I think that there is clarity that under the indirect tax, whether under the present GST regime or earlier, these two will be considered as separate persons, and the relationship will be of the service provider and recipient. Now, in this context, let's also see that this particular like trust. So this trust is not unique in venture capital fund. In fact, mutual fund also are there, which are identical on the principles. And in fact, the judgment also says that this is nothing but a mutual fund. So having said that this is akin to mutual fund, then whatever the principles are applied in the mutual fund, that also should have been applied in this case. But then they, without any reason, they made a differentiation. I'm not able to place why the mutual fund and venture capital funds should be treated differently, when the only difference which I can gather is that mutual fund may be investing in listed fund and venture capitals are investing in unlisted fund, but both are issuing units. So I'm not able to apprehend why the difference. Just one more thing. One more thing. That under the previous service tax regime, there was a clarification from the board that entry load and exit load will not be subject to GST, subject to service tax. But under the GST, there was a FAQ by the CBIC, which says that exit load will be liable to GST. And our understanding is that entry load and exit load are being considered as a taxable service, and on that tax is being paid. So here where I think your answer gets clarified or answered, that trust and beneficiary, the relationship.
I think, yeah, I mean, I think obviously that the position under the indirect tax seems to be clear in terms of the nature of relationship between a trust and a beneficiary. But you raised a very valid point that today a trust is as a vehicle is not limited to a VCF and or AIFs. I think it's a preferred choice for many other purposes. Including, I think, if you see some of the regimes like REITs, InvITs, mutual funds, as you rightly said, and also some of the other structures would end up using trust as a vehicle because of the principle of mutuality and also from a regulatory perspective, the fiduciary responsibility and liability that comes upon the trustee and the manager. So it's driven more from that perspective, that trust has been a preferred vehicle for all of these. So very clearly, I think depending on where and how this ruling kind of evolves, and then unless the policymakers feel the need to kind of interject and kind of correct the position under law, if at all, maybe from a wider lens, I think this ruling, as I see, can also have far-reaching implications for many other structures. In terms of how they would be kind of impacted by this. So I think it's going to be something worth looking at. It's moving on, I think, to the core of the issue, if you may look at it, and that's the carried interest. And Bijal, I was coming to you on that, and I think, as you mentioned, carried interest is really, if you really look at it from an industry perspective, that's really one of the core to which a manager who's basically the arranger and manager for the fund is really in the business for. So to that extent, I think obviously this ruling seems to be going to the heart of questioning that nature of relationship and the nature of compensation. And in my own view, India seems to be obviously jumping ahead of where the world has kind of really seen carried interest and how they've seen it. And maybe even in the context of a more developing market where the economy needs this long form patient capital to work for the benefit. How do you see from a carried interest perspective, at least, do you see this, some of the observations from this ruling kind of triggering some consequences on one hand, and secondly, we'll come to what kind of learnings, I think, which is important for the audience here. Are there some learnings for us under the ruling which can be applied?
Sure. So as a consequence, I would feel that yes, of course, if an income tax regulator was to essentially see, the arbiter in this particular ruling in itself, to that extent, of course, there will be some level of a trial to start, raising inquiries with respect to carried interest per se. However, a very important principle which we must note in our income tax law is a principle called income diversion by overriding title. Now, here we have a principle wherein under the documents itself, if at all an investor and the manager have agreed to essentially have the income on a particular kind of an investment diverted to someone else, so long as the documentation per se is clear in the sense it is not considered performance fee or any of that, to that extent, the principles of income diversion by overriding title should actually trump it, right? So from an income tax perspective, that would be an extremely important point. Uh, on your question as to what would be the learnings which could be applied for fund managers, here I would say that to the extent possible, it would always be, I would say, preferable to essentially have the carried interest subscription, which now in any case is most often done through carried interest trust structures or directly by some participants in the carry or in the disproportionate fee sharing, essentially try and avoid a situation where it is the investment manager itself which has a line item which of management fee which is subjected to GST, not be the recipient of carried interest. That would be one. Very clearly, this particular ruling has not, has more alluded to the fact that any expense which is essentially, considered borne by the trust, is considered as, exigible to a service tax. It is only in that particular breath that they have picked on all these expenses, including what they call a carried interest, because the fund documents did have a situation, or rather the internal documents did really refer to, as per the tribunal ruling, some performance fee. Second, I would say an important principle which, I would say important to bear in mind is to ensure that the legal analysis really meets the documentation. As much as there is a strong principle on income diversion by overriding title under income tax law, there is also an anti-abuse regulation which we have in place in India, wherein income can be recharacterized if the nature of the documents is such. Now, in a situation where the nature of documents in itself considers it as a fee income, to that extent, yes, it could be recharacterized. But in a situation where the nature of documents do not really call it so, then in that situation, it's very difficult to apply, the decision of the tribunal in the, of the CESTAT in an income tax proceeding. So documentation, even be it internal, is extremely important. Third, I would say, which very, very important, is on the issuance of these particular carried interest units, right? And we have seen very often it is not a question of the manager really receiving these units itself. It's basically anyone who's ready to really subscribe, and which essentially, it could be, varied people who would essentially be subscribers to this carried interest unit. Very important to note is that the timing of the investment is key here. In this particular ruling too, the tribunal has taken note that the carried interest units were issued very close to an exit per se. And that did not really hold, did not really help the case, right? Of course, there is also an income tax angle as to why the carried interest should not be issued very, later in time. And it is always better to issue it, at the initial close or much prior to the final close per se. However, that is an important criteria. But of course, I would say, the past is always wisdom. And of course, this is a ruling, of a tax year of 2005-6, right? So of a fund of 2005 or 6. right? So to that extent, yes, I mean, in the previous days, you may have, had carried interest units subscribed to much later, but as a learning, that's an important point to really note. In any event, it is required from an income tax perspective too. But otherwise, on the other principles of doctrine of mutuality, etc., the income tax authorities in its own, rulings have actually accepted this principle. Not only in ICICI Ventures' own case, but also when we look at the AIG ruling of 1996, right? In which case they've always considered a trust as not separate from its investors. And to that extent, that particular doctrine very difficult for it to be accepted under income tax law.
Interesting. So what I hear, Bijal, I think obviously there is clearly learnings for us from this ruling, and for all of us as stakeholders in this industry. I think we got to obviously constructively look at some of the observations here. But obviously, one of the questions which I think a lot of the audience and also kind of goes in our mind, that is trust as a vehicle now more susceptible to this versus any other form of vehicle, and which is, say, a partnership as we've seen evolve in case of AIFs. And then is this ruling or anything that we see here is from both from a direct and indirect, I'll come to Dinesh separately, but also from a direct tax perspective, do you see a merit where the industry may start looking at one over the other more favorably, or you think that may not be necessary? I mean, what are your thoughts on that?
Yeah. Okay. So, from an income tax perspective, a trust per se is a pass-through vehicle, right? And when we look at internationally too, any pooling vehicle, the crux of such a pooling vehicle has to be an automatic pass-through status, which a trust provides under income tax, right? When we look at an LLP per se, yes, I'm sure there are going to be many discussions as to whether an LLP should be used or not. However, very important to note that this particular industry and the tax around this particular industry has all been evolving over the last 20 to 25 years, right? We had a situation where a pass-through was only given to 9 sectors. Now, in those situations, it always made sense to have a trust vehicle, which would have been sure of having a single levy of taxation and be a vehicle which would be more acceptable to investors globally. Now, to that extent, yes, though an LLP is a form of vehicle which could be considered, I would say an uncertain measure would always remain as to whether, if at all, again, the tax laws essentially undergo a change by providing some, conditions to obtaining a pass-through status. Would you not want to be in a situation of having an automatic pass-through under the general principles of tax? So I think that is the way, I would really look at it. And of course, I would say very, very important somewhere for there to be a regulatory measure, given the importance of this particular industry as to how they really would like such a vehicle to be set up as.
Got it. No, I think, and maybe I'll also come to you, Dinesh. I mean, obviously, the principles laid down out here, and again, as I mentioned today, the regulatory framework allows one to set up a fund and an AIF in the form of a trust or an LLP, and also a company, because obviously from a regulatory side, they've all seen them equally as a pooling vehicles without going into the merits of the constitution of that vehicle. Do you really think the ratio established out here, and then is it narrowed down specifically to a trust vehicle at one end, and then may not apply to any other form of vehicles? Or do you think the knock-on effect of the principles laid down over here can also go out and extend to any other form of vehicles with a similar arrangement, especially with respect to carry, etc.?
Yeah, so Sid, you are right. In fact, the way the judgment has been drafted and pronounced, it, as I said in the beginning, that it is going to have a wider ramification, because the essence over here is that what they are saying, that your expense size is consideration. So like the Arving Council for the Appellant said that, will you consider the expense side of the balance sheet of a listed company to be the service provided to the shareholders? Because that also you invest money, and that by investing that money they generate business, what mutual fund is also doing in form of investing into the listed company or unlisted company, they invest into business. So there was no answer to that. Secondly, this particular where disproportionate revenue has been distributed, in the sense that Class A has got say 10%, whereas Class B has got 200% return. So if we are going to see all these things only from the prism of proportionality, then it may also apply even to the partnership, where different partners have different kind of share arrangement, because one is a working partner, other one is a sleeping partner. So in a way, one can say that sleeping partner and working partner, the difference between pro rata return is nothing but a service provided by the partner to the partnership firm. So all those things are possible, but then let me also say that department has got a tunnel vision. So tunnel vision is that right now, whatever is stated in this, they will go only with that angle, and they will target all VCP and the fund manager. Fund manager is not directly in the hit list in this, but then I believe that tax authorities has understood that if it is being treated as an expense side item, that means it must be treated as an income side in the books of the AMCs, and therefore if it is a performance fee, then it's nothing but a professional income which should be subject to tax. So immediately I believe that not even mutual funds are going to, until unless some enterprising officer comes and he says that what is the difference between this venture fund and mutual fund, both are one and the same, and let's go and hit even mutual fund. But then present danger is this, but then future danger, or because we are not having dearth of the enterprising officers. And once the officer has started a journey, then only Supreme Court can stop it, or the change in the law can stop it. Before that, there is no stoppage.
No, I think that's very well said, and I think obviously that goes to the root of the fear and the concern in a many ways for the industry. But maybe on this one, what's coming out clearly, yes, there is always a risk that independent of the nature of your entity, the as you rightly said, an enterprising officer can obviously start applying ratios that have been laid out in this ruling to other structures as well, and that risk cannot be ruled out or eliminated in a way. But at the same time, I personally feel, I think also you said that the authorities have a tunnel vision, and currently the focus seems to be on these trust vehicles, and something where the facts are laying similar, that's probably where you probably will be more vulnerable. And in that context, definitely, at least I think from a practitioner's perspective, I think maybe it may be tilting a little bit more in favor of partnership, because in the Indian construct, a partnership is not just for a fund vehicle, it is for any other operating business. And where if they kind of start raising some of these ratios of a differential distribution inter se between partners, I think they'll have a far more pushback, and then possibly may have to look at it very, very differently. But at the same time, I think Bijal, you very rightly said that this is not necessarily a determinant, at least from a direct tax perspective, that the vehicle choice of vehicle being a trust is going to be at a disadvantage in a way compared to a LLP. So I think that's a very important learning. But definitely, I think for the participants here, and just before we come to conclude, I think I would also like to once again let the participants know, if you have questions, please do feel free to kind of put it on the chat box, and I do hope the organizers have enabled that. But please do feel free to drop in your questions. We'll try to take them along as well. But I mean, I think very clearly the message, as I see it, and I think having seen the industry evolve and also the policymakers kind of look at this industry, and then maybe while we wait for the resolution to some of these issues, I think very clear need for each of us to re-examine our structures, and also, of course, ensure from a documentation and other perspective, assess the risk. I mean, I think, as I said, the cat is out of the sack, and I think obviously now the carried interest issue has been brought to the fore with this ruling in a way, and then to that extent, we obviously need to prepare ourselves and ensure. Well, you may not be able to eliminate the risk always, but you may be able to assess the risk better if you are a little more proactive in terms of looking at your structure, your documentation, and obviously prospectively apply some of these principles in a manner that would at least help differentiate the facts better and then mitigate the risk for all of us. So I think before I move to the concluding remarks from my end, but any last comments from you, Bijal and Dinesh, on this for the audience?
So perhaps I'll just say one, sentence. I don't think we should really jump the gun and get extremely paranoid about this particular judgment. There were, peculiar, I would say reasons not necessarily acceptable, which, led to this particular conclusion. However, it is extremely important, to be very clear about documentation. And of course, hopefully the policymakers will look at this industry and actually, take a decision on how they really want carried interest to be taxed, just like other countries around the world, realizing the significance of this particular mode of capital have essentially undertaken.
Got it.
Dinesh?
Dinesh?
Yeah, my take will be that since it's going to cut on two sides, one is directly to the beneficiary or subscribers because 12%, 18% tax or GST on that expense side is going to be a huge setback, as well as enhanced service tax or GST liability on the fund manager. So as I said, that it's going to take a time to get this resolved, but then this is something which is occurring on daily basis. So they need to take immediate steps to resolve it. Either they can go to advanced ruling authority under the GST regime so that they can clearly spell out, and based on that they can take a business decision, because in my mind carrying a huge liability of GST in your books is not advisable. Second one is that in any case, as this particular judgment throws us, documentation and housekeeping is of very paramount interest. So even if you have misspelled something or done something knowingly or unknowingly, you never know when it can come and hit you, because service indirect tax department is one which can encroach upon your home and offices, take away your disk and files, and they can be very meticulously examined. So you cannot be just careless about this terminology. So housekeeping and documentation are of paramount interest, not only in this, but in any other business organization, at least from the indirect tax perspective. So for me, these are the two learnings or two things which I wanted to highlight.
No, I think very, very well articulated. So I think obviously before we open up the floor for more questions, if any, but I think the message that one I would like to give, I think to the policymakers, and then I think maybe as an industry, as a body, as an association, we really need to impress upon this, that let the principles, and I think as we've seen and heard arguments on both sides of the story, and maybe ultimately it will be the Supreme Court which will probably determine which way the position stands on the law. My only request, and I think a submission to the policymakers would be, I think one, they really need to apply a much wider lens to what this means for the industry and the need for this capital. that the country has on a long-term basis. And I think where simply applying a revenue lens to this and using the disparity or the disconnect between various regulatory framework and treatments of a vehicle, one should not kind of miss out on the broader economic perspective. And I think clearly as a country, we have seen and supported the growth of this capital, taking this ruling to a level where the real core of to the arranger or the manager of this capital is going to be disincentivized significantly, and more importantly likely to create a lot of uncertainty for people, is definitely going to be hurting the industry in a big way, and even the global investors' confidence into the country is likely to see a bit of a shake-up with what's happened now. And we don't want, and as we had all experienced in the last few years, when the tax uncertainty, there was a stunted growth combined with what we call the brain drain, where we had a lot of GPs and others setting and managing funds from offshore and staying offshore. I think we don't want that as a result of a very myopic view of trying to recover a small revenue out of this, and then using the arbitrage in that sense. So I think that is one thing very clearly the government and the need to recognize. Secondly, I think obviously we don't want, and I think as an overzealous authority or officer, we don't want the tentacles of this ruling in any way to start kind of percolating down to other trying to really create and then establish their grounds on this, because that to me will be again creating a lot of uncertainty for the players, a huge litigation risk which has obviously got created with this, and that's something which is clearly damaging to what we are trying to achieve out of this industry. And then a case in example was the year of pandemic, and I think if you really look back, one form of capital which has really come along and stood besides the government in terms of supporting the businesses for commercial reason. I'm sure there is no reason why it should be done otherwise, but it has really proven that strategically India needs this form of capital. We have created incentives for players to really come in and invest. So there is definitely a need, if the policymakers need to address this through a framework or law, I think it is time for them to really rise to the occasion and really, as one would look at it, nip this in the bud, than letting this really go to a level where people may start, the brand image of managing India or India as a global destination, both for investment and management, gets tarnished. And I think from that perspective, I really would think it is important enough for the policymakers to step in, consult with the industry, and find a regime which is obviously a win-win and a conducive regime and aligned to what's happening globally, to really keep the country more competitive and attractive for the investors. So I mean, I think that's where I would like to kind of conclude, and then obviously we will be open for any questions from the audience. I don't know, organizers, would this be possible to open up audio for the attendees, or how do you propose that we take the questions? So I think maybe I mean, I am probably not able to get the full chat window on that, but maybe I think we'll give a couple of minutes. But while we wait, sorry, Mitesh. Are we able to open the floor for questions, audio, or we'll have to wait for it on the chat?
So we have sent the questions on your email ID.
Sorry, on the?
On your email IDs.
Oh, okay, okay. I'm so sorry. So we'll take a look at it. For some reason, it was. Okay, I think we do have a set of questions. So I think one of the question I think we have answered is with respect to anything can be done for existing funds on the documentation. Is it good to reassess any inconsistencies? I think definitely we said that there is probably a homework that is required to be done, and definitely to the extent that we are able to address and some of these issues which have been raised, definitely worthwhile. Right. I think one of the question is as to assuming this judgment is upheld at a higher level and given the amendment in the GST law, would future carry be categorized as performance fees? If that is the case for income tax purposes also, then it would be considered as a performance fees. I think we may have answered this question as a part of our discussion, but any thoughts from you, Bijal or Dinesh, on this?
Yeah. Sorry. Yeah. So to the extent that, I mean, trust providing services, I mean, clearly under trust law, because a trust is not an entity, difficult to really say that. And in any event, if at all there is someone providing services, it can be the trustee and not the trust per se.
Correct. Okay. So, and then I think you rightly said that the ruling may have a different application from a direct tax perspective. So I guess that position seems to be quite clear in the law. Sorry, Dinesh, you had some reaction to that. Sorry, Dinesh, are you able to hear us?
You're on mute, sir.
Yeah. So what I was saying is that although this judgment is rendered in the context of service tax, but the principles are very much applicable under the GST era also. So if this judgment is upheld by the Supreme Court, then certainly this carried interest will be considered as a performance fee and will be taxed in the hands of AMCs.
Yes, we do have a lot of questions here. So one is again back to you, Dinesh. Should a fund obtain a GST registration going forward to help accumulation of GST credit, which would be available for set off in case of a GST demand?
So my answer will be that trust is a taxable entity, and if trust does some like registration fee or some other fees they charge from its contributor, then certainly that amounts to taxable income for the GST purpose. I see no harm creating a small avenue for the purpose of payment of tax and getting a registration so that they can accumulate all ITCs, and then going forward, if that liability becomes, then this fund can be used to set off the output tax liability. Otherwise, yes, there is a time limit prescribed under the law to avail the ITC, and if revenue neutrality, which has been fortunately granted in this particular case, is not granted going forward, then there will be a double whammy to the funds.
I think another interesting question, I think, and then maybe relevant for a lot of them. What happens in case of a fund closure where no GST has been discharged on a carry? Who can the GST authorities go after, fund or the fund manager? We are all hoping that none, but I think if it has to, based on the ruling, would they go after? So if the fund itself, which is treated as an entity, has been wound up, because all of the funds would have a finite life, is there a successor liability construct under the GST law, Ganesh?
Only in the context of partnership, we have seen it, not in the context of trust. So I don't think that trustees can be called upon or held up by the department.
Right. I think one question which I think we may not need to answer today is who bears the GST cost on carry, GPs or LPs, or this needs to be negotiated. I'm sure that would be a big point of negotiation. I really think if it is being taxed as a performance fee, the pushback obviously will be from the LPs to kind of pass this on to the GPs. I think another question is, can this order impact securitization trust, especially with different classes of PTC units and originators acting as a servicing agent? I think this is a question from Supriyo. I think this is a very interesting one, and in fact, that was something we were debating internally. So, Dinesh, do you want to share your thoughts on that?
Sure. So as I was saying earlier, that this ruling, if it is to be seen, then anywhere where pro rata contribution or distribution has not been made, and the holder of a different class of unit is also a service provider, then there will always be allegation that consideration has been shifted from one bucket to other bucket only to evade tax or to reduce the tax liability. And indirect tax authorities, they have long experience in these matters, where we have been investigating in past whether the software value has been increased and the equipment value has been decreased or not. So that has been a consistent investigation across board. And therefore, in this also, wherever one person bears both the heads, we are going to have this problem.
I think, and then my 2 bits on it is really, while the principle may be applied across board for any other structures, and I do hope that it does not, but if it starts hitting the real commerciality of investors trying to create a differential kind of distribution structures, and I think we have seen enough of those, like PTC is a classic example, where you may have a senior and a junior subordinate class of units, etc. I mean, I don't think that principle, I do hope that the GST authorities do not go down into that element of determining or allocating any superior returns to be taxed as a services, and I do hope that some sense will prevail on that. But so moving on, second, I think we have a question, Bijal. I think you may have answered. This is from Jagisha from Omidyar. I think will LLP form be at a different footing on this position, both maybe from a direct and indirect tax perspective?
Yeah, so perhaps from a direct tax perspective, yes, an LLP, per se, because under law as well as under income tax law, differential profit sharing ratio, which is disproportionate to your investment, has been an accepted judicial position. To that extent, yes, it would work. However, there are commercial ramifications as to whether or not this will actually be something, which will work from the manner in which, carried interest programs are really rolled out.
Okay. So I think we also have a question from Chetan from Kotak. I think what will be the impact on various unincorporated JVs entered into, where each JV partner contributes his expertise and other expenses? And I think this was the debate that we were having internally as well, as to a partnership where you may have a working partner and an investing or what we call a sleeping partner in a business. I mean, is this all going to get into a question out here? I don't know, Dinesh, do you have
it's unlikely that. Yes, that's very interesting, but in my view, it's unlikely, because when we are saying about 2 joint venture partners, both joint venture partners are working together, and therefore their profit ratio will not be questioned by the authority unless one joint venture partner also becomes a service provider to the venture. So my only limited submission is that until one person bears both the heads, we are not going to have this risk.
Okay, okay. So very important, and I think that's one of the learnings, as we call, from this, as to structurally how do you ensure that some of this is taken care of while setting up of these structures. If the LPs are foreign investors, I think this is a question again interesting. Then can we claim a zero tax exemption and thereby claim refund for the GST that is paid on the fund management fees by the fund? I don't know.
No, I don't think, because fund manager will be construed as an intermediary, and their place of supply will be the location from where they are providing service. So if fund managers are located in India, being an intermediary, they will not be able to export, although they will be earning foreign exchange, but it will be construed as a service, location of service provision is India. So it will not be zero rated.
And then in a way, this also goes to the heart of how the authorities are treating the trust as a separate entity. And to that extent, if the services are being rendered by the manager to an Indian entity, I mean, there may be a lesser of a case to seek any foreign export of service exemption to that extent. I think there's a question for you, Dinesh. Will not the decision of a larger bench of Supreme Court in Calcutta Club, Ranchi Club, that there can be no service provided by club to its members on the principle of mutuality apply in this situation?
Yeah, in fact, Tribunal has examined this case, and what they have said is that there is a distinction between a trust and a club. Club takes contribution from its members, and then it uses exclusively for the benefit of members. There is no third party involved, and trust is not there in the profit venture or commercial profit aspect. Whereas in this particular trust, the very purpose was to generate profit, number one. Number two, what they have said is that you are not giving return to every contributor in the same manner. In fact, there is a differential treatment. So the differential treatment has led to destruction of this club equivalence. So Tribunal has very clearly said that both cannot be treated at par. So the that has been examined now until a Supreme Court examines it otherwise.
Okay. I think the other question, is whether investors who receive carry interest need to pay service tax. I mean, very interesting question, and I think obviously what it could lead to is the absurdity, because in many cases you do end up sharing this carried interest with LPs, and then based on the commercial arrangement, where the LP, besides putting in money, is not providing any other service, and is obviously so I think it may be difficult for the authorities to tax that part of the distribution as being taxable or subjected to service tax. I would believe so, even though there is a disproportionality attached to that class of also very important, will this tax uncertainty, this is from Shrikant Daga, will this tax uncertainty result to offshore structures and IFSC structures being preferred? Any thought around Gift City specifically? Bijal, you want to take that?
Sure. Yeah, so I mean, I would say definitely from, the Gift City structures, perhaps may actually have a sigh of relief on these, on this, given the fact that, GST does not apply there. And to that extent, there is no motivation, I would say, for, the tax authorities to really, recharacterize or, consider it as a taxable event. Of course, from an income tax perspective, there's not really been any judicial development. So, to that extent, that's so long as, the documentation and the nature of the same is clear, I don't think there should be an issue.
And then just to add two bits on, I think there will be definitely, and then we are starting to see some thought process that where today there was clearly pooling onshore in many structures where you were essentially pulling your domestic and offshore investors onshore AIF. I think a lot of them may start looking at doing this pooling for at least for offshore, because domestic investors are not allowed to put money into GIFT yet freely. But at least for the offshore portion of the investments, if that can be structured through GIFT and any performance fee, etc., or carry is really paid at that level, I think that may bring or rather reduce the risk in a way. So I guess as they say, this might trigger some more action in GIFT is our sense as well. I'm mindful of time, and I'm trying to. We may not be able to answer all the questions. I think Nakul had asked, in case of a fund where sponsor and investment manager is the same entity and the carried interest is attributed entirely to this investment manager sponsor entity, would the implication of this ruling be any different? Bijal, you want to take that?
Sorry, Siddharth, can you just come again, please?
Yeah, in case of a fund where sponsor and investment manager is the same entity and the carried interest is attributed entirely to this entity, would the implication of this ruling be any different? I don't think so. I mean, I think you are actually bringing it much closer to the facts out here. So it, as we heard earlier in the session, I think separating the entities which are drawing carry versus those that are rendering services would definitely be advisable. I think that's the way.
Absolutely.
Sid, just to add over here that
Sure.
in fact in judgment also they are talking about piercing the corporate veil. So they have discussed that. So even when you have created multiple entities, you are not out of one. So if you are having one single entity, then you can certainly look at.
Yeah, no, that's correct. And I think I agree that by separating entity in itself may not be sufficient, because I think they have also looked at the EWT as well in the construct of this ruling as well. And then obviously the separation out there. But definitely, I think some of the things like meaningful investments coming through these entities, entities not directly rendering services to the fund, I think a lot of those factors could help potentially differentiate the facts. And to that extent, I think definitely advisable as against capturing all of it in the same entity, because that definitely runs a higher risk in a way. I think we also have a question from Siddharth Pai. It says getting input credit in a fund will be problematic as the sources of income, cap gains, dividend, interest are out of the scope of the service tax or GST. But wouldn't a GST registration and changing any income to the investor, charging any income to the investor constitute income from business and profession, thereby resulting in a tax pass-through under the Income Tax Act going away? I think maybe Bijal, that's probably. So the question, just to repeat, wouldn't GST registration and charging any income to the investor constitute income from business and profession? I think I think I get the context, because the tax pass-through is conditional upon the fact that there is no business income in the hands of the AIF, and if the business income is there, then obviously the tax pass-through goes away. So the concern is whether any of this would lead indirectly or otherwise to this being treated as business income and hence a loss of tax pass-through. I think interesting point.
Yeah, very interesting. I mean, I'm hoping we don't really come to that.
I don't.
That will really be a trouble for the industry. But yes, I mean, that's if at all the argument that the trust is a separate entity is sustained, for income tax purposes too, then of course, I mean, that would be a very natural corollary to the outcome.
Yeah. I think there are a couple of other questions regarding differential class of units. I think we've answered that, Sid, but I think if there are any follow-up questions, please do feel free to drop a mail. I think we are almost close to 4 o'clock, and we don't want all of you to be kept away from the Friday evenings. So I think last question, is there any anomaly between direct tax and indirect tax with regard to treatment of trust as a legal form? I think this is from Jagisha again. I think we did highlight that it indeed seems to be the case that clearly that indirect tax has disregarded the mutuality as a construct in determining the status of a trust versus how the direct tax has looked at it. So, I mean, the positive side of it is clearly the direct tax seems to be recognizing the mutuality and non-recognition of trust as a separate entity, which is not the case in case of indirect tax. So I think that I mean, my apologies if we have missed out any of. I think one of the question was that does this create any concern for any global taxability of global carried interest? I don't know, Bijal, if you want to have for any global fund managers, and I mean, I don't know whether this ratio in any way impacts global carry.
Right, right. I mean, to the extent that, I mean, perhaps this particular judgment may not really have a ramification from a GST perspective, because even if at all it's considered a a service rendered, it would be exempt under the offshore supply of services. However, if at all this particular proposition does hold true vis-a-vis, income taxes, then in that situation, it would equally apply to global carry structures wherein you have Indian participants. However, pure global structures with the entire participation outside of India, that should not really be affected by this particular ruling.
No, absolutely. I think, and that's correct. I think at least while the global regulators, tax authorities have not, and I think maybe consciously reined in by the policy makers for in some cases or otherwise, I have not kind of ventured out to really disturb what we call an equilibrium that has been established in respect of PE industry. I think we definitely don't want India today to really be setting the tone of how and irrespective. I think, as I emphasize, we really need to look at this very, very differently, independent of the legal principles that exist here. So I think with that, I would really like to thank first and foremost both the panelists, Bijal and Dinesh. I think it has been an engaging discussion, at least for me, and I'm sure the audience would have obviously have something to take away from there. And thank you so much. And last but not the least, to all the participants, we do hope that you found the session useful, and definitely please watch this space. We will be watching this very keenly and following this, and definitely keep you all updated on how this progresses. And at the same time, to all those who have the ability to kind of engage with policymakers, we would be doing that for sure at our end, and then definitely would encourage all of you to do that as well. With that, thank you very much, and we'll put a wrap to this session. Have a good weekend ahead and enjoy your Friday evening. Thank you very much. Take care. Bye.
Take care.
Thank you.